This conference will now be recorded.
It should be okay.
Yes, I am. Yeah, my mic is muted. It's not me. Then here, hold on.
Hello.
Mine's
Testing. Hello.
it's like ringing. It's not me. Oh, that's got a mic up there. Do you need a chair? Now you know how to I'm like. Yeah, that was just starting. Better?
Hello. This is Ryan from Mitchell County. Can you hear me?
I can. Can you hear me?
Yes, sir, we can.
Okay, good.
It is now 10:33, but I think we should still stand there.
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you for being patient with us during this. This is the Mitchell County Board of Supervisors meeting. Today is Tuesday, August 12th, 2025. Starts the meeting at 8:30 a.m. You have the agenda in front of us. Is there a motion to approve? And second. Opposed? Tim's got a little bit of feedback there.
Tim's having trouble hearing.
Whoever just spoke, I could hear well, but I was not able to hear the motion or any of the other speakers.
Sorry, I'll speak up, Tim.
They tease me I have a farm voice, Tim.
Well, if need be, maybe, Pam, you could just repeat the questions to me if I can't hear them.
Okay.
There is an echo, but better now. Okay, I think we'll go on. Discussion on proposed right-of-way ordinance with Tim Whipple and possible action. Go ahead, Dan.
So maybe, do you want us as a board to introduce ourselves, Tim? Or how do you want to handle that? We sent some questions, and I think Rich also sent some questions. I will probably defer more to Rich on some of those challenges or questions that he received. And we'll just kind of go from there. How's that sound?
Sure. I mean, I guess I'd prefer to be answering the questions people have. So I have had a couple conversations with Rich and given him some insight, but would take your direction or the board's direction on specific questions that you may have if I can answer them.
Sounds better to me. If the board's got some questions specifically on the ordinance, I know that, again, Tim and I have talked about some things to kind of understand it, but I think that a lot of things that Tim and I have talked about probably need to be heard by the board as well.
Okay.
Just for interpretation and everything else.
Right.
Jim, do you want to start?
I guess my main concern from the start of this has been the litigation that's been happening with other counties in regards to doing something that Iowa code doesn't allow us to do, the way I see it, 479B. And I know you have Iowa code 13 that you referenced. I believe it was 13.12 parent 1 and parent 2 as far as some of your justification. The main thing that the ordinance that you put together has required setback distances. And I don't know if this was patterned after Bremer County. I know Bremer County, I Googled that they're under litigation. So what kind of assurances do you have for us that we're not going to end up getting in a conflict with Iowa code and get sued on this?
Well, let me just clarify a couple points there. Bremer County has adopted a very similar ordinance, as has Emmett County and Wright County. And none of those counties have been sued over their right-of-way ordinances, at least to date. Bremer County was sued over its survey ordinance and its zoning ordinance, but those are different ordinances. The Utilities Commission, Chapter 13, that chapter implements Chapter 479B. And so under the administrative rules adopted by the agency, I provided those citations to you so that you can assess whether you agree with my interpretation that the Utilities Commission's rules allow us to permit the road crossings under local ordinances and under specific statutory authority under Chapter 318. But I can offer no guarantees that any county will never be sued. These decisions made by the pipeline company, if they would like to bring a challenge, they certainly can. And the question is really a matter of weighing whether you think our arguments are better than theirs, or anticipating theirs and who has the stronger ones. And to date, rather than sue counties over the road crossing ordinances, the pipeline company has opted to make a motion to the Utilities Commission, asking the Utilities Commission to declare that they're not required to get a road crossing permit from any county. And that would be a change. The commission has always required them to get road crossing permits. It requires them to file exhibits with the commission showing that they've obtained approvals to cross roads and railroads and rivers and streams. So it would be a change from prior practice, but that's one of the reasons that I sent the Bremer County filing, was so that you could see the authority that Bremer County is citing to the Utilities Commission for support of its ordinance, but there's no ruling on it. So, the consideration is for the supervisors to decide whether you want to try to do something at the local level in order to, clarify what you think your roads need and what you think your requirements are. Other counties have done it. Other counties have opted not to do it. And some counties that have wanted to adopt ordinances like this had similar questions, made similar assessments, and ultimately it's about probabilities and strength of arguments. So far, there's no court has ruled we can't do it, but no one's been challenged directly on the road crossing ordinance.
I think that would be sad if it was changed so that they were not allowed, or excuse me, that they were not required to come to the county in regards to discuss with us. I think that's very good, and that's pointed out in Iowa Code 13. So I think that's excellent. They need to come to the county and talk with us, and we might have, as the way it says, we may have jurisdictional interests. Well, we do, and I'm all for them doing it the correct way. They have come to us, we have a utility permit, so they need to come to the county, they need to fill out the utility permit, adhere to the guidelines in the utility permit. In the utility permit, it also says that we will not conflict with certain Iowa code items. Part of that is 479B. So they need to come to us, fill that permit out, but the IUC has jurisdictional authority to route the pipeline. And in your ordinance, when it says required setbacks, that word required just triggers a red flag for me. That's my personal interest. Maybe not these other board members, but it is for me. If it said guidelines, I could accept that. But required setback distances is just, it's a not sell for me. That's my thought.
I mean, if you're looking to try to, for me to try to talk you out of it, it's not my place. I would just say my view of the statute is different, and of our county road crossing authority, my view is different. And unless a court rules that we don't, my view of these statutes is that we have strong authority to do this. But again, I can offer no guarantees, and it's not unreasonable to talk about, changing the setbacks or taking them out. For example, the 250-foot setback, I think that reflected a concern by the Wright County engineer to make sure that the pipeline wasn't placed in a zone where they wanted to expand bridges in the future when they rebuilt them. I think that's a highway-based concern, and I think that's a traditional concern of counties that we have specific statutory authority to adopt. Nothing about the ordinance prevents the Utilities Commission from making other routing decisions or prevents them from issuing a permit at the state level. The pipeline company simply has to propose a change in where it crosses the county highway. Now, the question is whether you want to eliminate any risk of a dispute with the pipeline company, or whether you want to assert some local prerogatives and local priorities. So, I can't make that kind of a policy decision for you, of course. I can only tell you what I think the law allows you to do, and then within those parameters, really supervisors have to decide.
And I don't want to come across as I'm trying to get in an argument with you, or I do respect your opinions, I do, but I just also want to make it clear as far as what my concerns are with it. That's all I'm trying to do.
Sure, I certainly understand that perspective. There's the assessment of risk or the tolerance for it is always an appropriate consideration. So I'm not telling you shouldn't have that concern. I guess I thought, Rich, maybe there were going to be a few other questions about the ordinance in particular. Maybe you want to, I guess, tee some of those up, or
Remember, there was just an that was the one that Jim brought up about the wording of whether we require the requirement of distances versus recommendation. And my only concern with recommendations is it's not, it's minimum, right? The way it's worded now, it's minimum required versus if you recommend it, then there's this, I think there's this other arm of negotiation then that says, well, why do you not want to go? If we keep the wording the way it is, then we have the opportunity to say, okay, let's look at this specific location and say, okay, well, this is the minimum, but then we've got the waiver that allows us to say within reason, we can accept the waiver or issue a waiver and say, we're gonna change that distance for this specific location at this specific time. But at
Right.
least they have guidelines to go in right now and say, if we're gonna route something, this is what the county says we have to have. So let's work with our private landowners to get the routes kind of where these are required now, so that they don't have to get their routing from the private sector, then come back to us and say, well, okay, this is where we want to put it. Well, we aren't comfortable putting it here. Now you got to change your whole route. That if we have something set, then they've got to look at that as well as what the IUC or whoever they have their setbacks already on the private side of things that they're required to do. If we have our own setback requirements, if we're going to call them setback requirements in the right of way, they can work with both the private and the public setbacks to determine a route that's best through the private property as well, without coming up with a private route, then coming to the county and saying, oh, well, darn it, this is where we planned on doing it, now we got to change it.
Right. So
That's my only concern is what I think the wording should probably just stay the same, so we have something to work with that they do, and then these are the minimums, and after that, let's take a closer look at it, and see if we can find, common ground as to whether we have a waiver for a specific location.
So with respect to that general issue, I'll just say candidly, I don't think it's workable in an ordinance to make it optional or to have it be, recommendation. The way that requirements and ordinances are typically drafted is there's a set of requirements that are not optional. But if they impose a hardship, then there's a process for a waiver. And that's exactly what this ordinance includes. So, it's at 17 or so of the ordinance draft, but it specifically provides for a waiver for any situation in which any pipeline company or other, the ordinance is written a little more broadly. So, anyone who's covered by the ordinance has the ability to request a waiver by explaining the nature of the hardship, and it's all laid out there. And that's a typical process of local zoning ordinances, of local road crossing permits. This ordinance gives the county engineer some discretion in working with the permittees on how they do that. I do recommend that as a process. It's much more workable and helps you treat all applicants equally in terms of permitting, rather than trying to adopt recommendations. That's something that isn't really enforcing any requirements. So at that point, I would say either take the setbacks out, which is an option, or not adopt the ordinance. You're not required to adopt the ordinance, of course. But your current permitting scheme is, in my view, an implementation of the same statutes that the ordinance recites at the beginning in the whereas clauses, primarily chapter 318 and chapter 308, the authority of counties to, in fact, the requirement to permit excavations in the right of way. But the county currently doesn't have a really clear set of requirements for doing it, just the permit application, which leaves a lot of ambiguity in the office of the county engineer. Whereas, if you construct a generally applicable permitting scheme, then you can, be really clear with all applicants about what your requirements are right up front, and they can read it and then they can comply. You can do it as you're currently doing it, but cities tend to adopt right-of-way ordinances that are more like this. more fully formed and a lot more detailed in terms of how they do the permitting. But I've worked with other counties that haven't done it. You know, this issue of the pipelines in the last 3 or 4 years has caused a lot of counties to take a look at this and think about doing things more like cities have done. But again, right now you would be you'd be relying directly on the statutory authority that you have to require permits for excavation in the right of way. So I hope that answers your question, Rich.
So just to elaborate a little bit on the waivers, and there are certain things in here that the engineer is allowed to do the waiver. I believe there was 4 sections, if I remember right. In 14, it has placement of facilities. So the engineer, it says in here that the placement shall comply with separation requirements. The engineer can, with the approval of the board, so the board becomes part of that waiver process if the setbacks, in the world of the setback requirements. Other things, he can waiver, but with that, it becomes part of the board. And when you go back to where the waivers are, and again, I'm not trying to be confrontational, I'm just trying to discuss this is all. So in the waiver part of it, there's quite a process in order to waiver it. And if you look at section A, and then you have I, double I, triple I, number 4, number 5, each one of those has to be met in order to do the waiver. And when you start looking at other departments that are involved with each one of those, you're starting to look at the county attorney and the engineer, county attorney, engineer, and the board, county attorney, board of health, county attorney, emergency management. And then after all the considerations are found to be relevant, then the board of supervisors, either whether they deny it or approve it, have to put together a document that states why we did what we did. So it's not just one of these things where the engineer says, yeah, I think this is what we can do. There's a process involved with that. And you
That's
know
right.
that.
Yeah,
but I
that's
want
right.
somebody else to do that too.
Right.
Yeah, there definitely is a process, and actually, in my view, I think there should be a process. I think that it gives some checks and balances inside county government so that, you know, the engineer has a role, but so do the supervisors, and whether they want to waive the requirements that ultimately the supervisors would establish by passing the ordinance. So it gives permit applicants a chance to request waiver. It gives the county engineer a chance to express an opinion on them. And it gives the supervisors a chance to decide whether they agree with granting the waiver. So again, it does create process that you probably don't have today. So that should be part of your consideration, whether you want to implement a process like that for the first time.
If I can maybe respond to your comment about the checks and balances and the processes and the fact that, you know, granted, we haven't looked at these kinds of right-of-way ordinances or updating some of our policies within our county in the last 20 years because a lot of private entities have not wanted to come through our right-of-ways. And our right-of-way is something that we all as taxpayers have paid for. We've paid for those roads, those bridges, and those intersections and all of that to be put in place. So the fact that we do have the Iowa code behind us to protect that, and those protections are in place, we're doing a little bit of catch up. Without a doubt, the CO2 pipeline has probably sped this process up. But if it wasn't the CO2 pipeline, would it be another type of pipeline or another type of entity? And the difference being, yes, we had some utility permit processes in place for public utilities, but we didn't have things in place for our private situations and protecting our right of way. And that's what this is. That allows us to support the protection of our county right of way and put together a control process in place that Rich or the engineer can follow, we can follow, our county attorney can follow, so that we all have a clear definition of the process. There's no, when something all of a sudden arises, we're not sitting on our hands wondering what happened, you know? Mark, do you have any questions?
I'm okay the way it's written. If I was a pipeline company or fiber optics or anybody, I'd want to be as far away from a bridge as I could. The way the flooding and the way the weather patterns are, it's just.
Well, I think the distinction is and I don't remember which code section it is, where public utilities legally have the right to be in the right of way where private utilities do not. And so I think in general, this is trying to say, okay, we may allow you in the right of way, but you're going to follow our rules because typically you don't have that right to be there. Is that kind of what this whole thing is about, right?
I think you're referring to Iowa Code Section 306.46, Rich. That's the one that gives public utilities some rights to put their facilities in the right of way. But, you know, the statutory requirements in Chapter 318, which is all about obstructions and excavations and highway rights of way, requires any person to get a permit from the highway authority before excavating in the roads. So, but it doesn't really give a lot of specific details about what the conditions, restrictions, requirements on the crossings should be, or what the procedures are for it. That's all at the local level. And so you do see some variations from county to county on what procedures they'll use, or what terms and conditions they want to attach to the crossings.
Todd, do you have any questions?
Well, I guess it's been saying all along is I definitely think we should raise our permit fees. Definitely it hasn't been, but I'm willing to just wait out to see what happens.
So if I may ask, Todd, when you say wait out to see what happens, what are you referring to? Are you referring to wait to see what private entity comes through, or the damage that's incurred, and then what? Maybe is my next question.
If there would ever be any damage, I don't know. I'm not saying, or I guess I don't know if the pipeline will ever come through.
And let me maybe from my standpoint reiterate, this is not a pipeline ordinance. This is a right-of-way ordinance. So no matter, and we assume that whoever is gonna come through is gonna go underground. So it's probably going to be in the form of some sort of pipe, because we're burying everything underground now because we don't like to look at it, and for various other reasons. So we're gonna make the assumption that whatever somebody, private entity comes through, they're not gonna probably be hooking things across the county overhead. They're gonna wanna go underground. So it isn't just a CO2 pipeline thing, it's whoever is right behind. And there are entities in Minnesota that wanna come through. And in several other counties they're experiencing. It's not just specifically CO2 right now.
So our utility permit requires that any pipelines be bored under our roads, so that we already have that in place, that it has to be done.
Public
And
utility.
Pipelines, and if we needed to amend our utility permit, we certainly could do that, and I wouldn't have a problem doing that. The other thing is that I really do get tired of it being sold that this is a right-of-way ordinance and not a pipeline ordinance, because if it was not a pipeline ordinance, there wouldn't be so much dialogue in here regarding pipelines.
Okay.
This is a pipeline ordinance, or I'll title it. This is a right-of-way ordinance with setback distances for pipelines. That has to be very clear. You can say it however you want, but that's exactly what this is. To also comment about Todd's comment. And I asked you this question, Tim. So aren't we part of phase two, whereas phase one is actually where the pipeline is at right now? And when Todd says kind of a wait and see type of thing, isn't it fair to, I'll just ask it this way, isn't it fair to consider what happens in phase one with an ordinance to see how it affects phase one counties before we jump into it? Or, I mean, that's just a thought. I don't know how to even comment on that, but that's just a thought.
Yeah, I think that's an important point to be made. At the state level, what you're referring to, there is the first proposal, phase one, which includes certain terms and conditions the state placed on the state permit. And then there is phase two, which involves not one permit request really, but 14 or 15 separate dockets for different sections to connect up to the main backbone permitted in the first phase. And Mitchell County is not affected in the first phase, but in one of the subsequent dockets, which I refer to in a shorthand way as phase two. So I think there is a couple points to be made. There are a couple points to be made about phase one. One is construction cannot begin on phase one for a couple reasons. One is there's a condition requiring the pipeline company to get a permit in South Dakota, which has not occurred and may not occur. The second reason is the issuance of the permit in phase one is subject to a very vigorous challenge, both by landowners and by 9 different counties, saying that the board's permit decision was incorrect. And if those challenges are successful, then it's possible the permit decision would be reversed. That's the phase one permit, and that would then affect, the outcome of phase two as well potentially. But at the moment, it's an open process, and filings are being made, and the company is requesting eminent domain in its phase two applications. A substantial amount of eminent domain actually in the phase two dockets. And there will be a point, unless we don't know when it is, but where those phase two dockets will proceed to hearings in the various counties, and there'll be decisions on the permits that they're requesting. So I think it is useful to bring it back to your point. It's useful to recognize that there's still a lot of process that has to be, hammered out in phase one and in phase two. So the question of local ordinances is, parallel, related, but not specifically dictated by what happens at the state level.
So let me ask this question maybe in another way. So we just approved a windmill ordinance, correct?
Mhm.
And that's infringing on a lot of these similar types of things, setbacks. A lot of those kinds of things were addressed in the windmill ordinance,
There is a difference,
okay?
because Iowa code, there's no Iowa code that stipulates what we did in our wind turbine ordinance that is a violation of it.
Well, we're not in violation with a right of way, Jim.
But
We're not in violation of a right
that's
of
what I
way.
disagree with, because that would
Okay,
require,
and,
that's my disagreement.
okay,
Because IUC is the one that approves the routing. If we're
Well,
saying
I would like to jump in there. There is a similar statute that applies to wind and solar siting. And the Utilities Commission in Chapter 476A, there is a specific statute that allows cities and counties and zoning authorities to participate in the permitting process for anyone who's required to get a generating certificate. Frequently, wind turbine projects don't seek generating certificates because they can stay under 25 megawatts on a gathering line, but solar projects do generally need, if they're more than 25 megawatts in size, they do generally need a generating certificate. And there's an open docket in Cerro Gordo right now called Ranger Power, in which the solar company is challenging the zoning ordinance of Cerro Gordo County. So that question of zoning setbacks and their applicability to other types of utility infrastructure is as open a question, maybe more open than this road crossing ordinance.
Any other questions for Tim? No? Okay. Someone?
No.
Rich? Anything? No? Okay. All right. We have no more questions for Tim. Thank you for being here today. Really appreciate it.
Happy to participate and happy to answer any other questions now or after the meeting that anybody has. So.
Okay.
Thank you.
Thank you.
I will pop off then if you want, or I don't know. Are we ending the meeting?
No, we're
Hold
not.
on. I just want you to know, Pam, before you do any sort of motion,
Right.
we cannot put it in the papers this week because the deadline was.
Oh,
Yes, sir.
absolutely.
So if we could give another week and just put it on the agenda for next week, we can discuss it again. I would like to do a little bit more debriefing on my end privately with Tim, so.
Oh, okay, well, you would still have time because we wouldn't put it in because we've already missed this week's deadline. So we wouldn't put it in until the following week. So that's why we would set the public hearing for September 9th.
I know.
So does that
Just do
allow?
it next week. Otherwise, I won't have a very good. But it's up to you. Do you want to make a motion and I won't have the votes possible?
Well, I guess, you know, we're getting pressure from a lot of people in the county as to why we are not acting on a right-of-way ordinance. And I'm trying to be responsive to my constituents and to people that way. And I'm hopeful that that will still give you September 9th, would that allow enough time? Because the public hearing wouldn't be until September 9th.
If we get it next week into the paper before 11, it will still be. Yeah.
Right.
I just want to take what I've listened to today and actually.
Okay.
Get it all in.
So, and then you can follow
I'm
up
just not
with
ready
more.
to make any kind of vote, and if you want to put it to a vote,
Okay.
I will tell you it will not pass. So. It's up to you.
Okay. Well, I guess we'll hold off on setting a public hearing then.
Alright. Thank you again, Tim.
Thank
I
you,
appreciate
Tim.
it. I'll be-
Thank you.
All right, we're gonna adjourn the meeting at 11:09.
Raises that hash.
What am I supposed to tell you about that? They cut off the